Gwynne Wilcox, a former member of the National Labor Relations Board, NLRB, has filed a lawsuit against former President Donald Trump, alleging her dismissal was a blatant violation of the law. Wilcox contends that her termination was an unprecedented and illegal attempt to undermine the agency's independence, a claim she meticulously details in her legal filing. The lawsuit paints a picture of political interference within a crucial government body tasked with upholding labor rights and ensuring fair practices in the workplace. The gravamen of Wilcox's complaint centers on the assertion that her dismissal was directly linked to her dissenting opinions and rulings on labor cases, effectively punishing her for exercising her independent judgment and adhering to her legal interpretations. This, she argues, directly contradicts the principles of impartiality and independence that should underpin the functioning of such a vital regulatory agency. The White House, in its defense of the action, offered a starkly contrasting narrative. It characterized Wilcox and other dismissed officials as far-left appointees with radical records of upending long-standing labor law, suggesting their removal was necessary to align the agency with the administration's policy priorities. This justification, however, is vigorously contested by Wilcox and numerous legal experts. The assertion of radical viewpoints, they argue, serves as a thinly veiled pretext for political retribution, a maneuver designed to silence dissenting voices and install individuals more amenable to the administration's agenda. This interpretation is further strengthened by the swift and decisive nature of the dismissals, leaving little room for due process or reasoned deliber. The immediate aftermath of the dismissals sparked widespread outrage and condemnation, particularly within the legal community and among former NLRB officials. The near-unanimous condemnation underscores the severity of the perceived transgression. Lauren McFerrin, who served as NLRB chair until her reappointment was blocked by the U.S. Senate, unequivocally stated that Wilcox's termination was unprecedented, arguing that dismissing a sitting board member for their legal positions constitutes a clear violation of established legal norms. McFerrin's assertion is bolstered by her own experience, highlighting the political pressures faced by those in positions of authority within the NLRB. She emphasizes the critical importance of preserving the board's independence and safeguarding it from partisan interference. The implications of such actions extend far beyond the immediate context, potentially chilling dissent and impacting the impartiality of future decisions. Wilma B. Liebman, a former NLRB chair who served under Presidents Obama, Clinton, and Bush, provided even stronger criticism, characterizing Wilcox's dismissal as brazen and shy. Liebman, a figure with extensive experience and deep understanding of the NLRB's operations, asserts that the termination directly contradicts established Supreme Court precedent, the explicit language of the National Labor Relations Act, NLRA, and decades of established practices. Her statement carries significant weight, given her long and distinguished career and her nonpartisan background, spanning multiple presidential administrations. Liebman's perspective highlights the profound implications of the dismissals, raising serious concerns about the erosion of institutional integrity and the potential for future abuses of power. The sheer weight of experience and authority behind these criticisms speaks volumes about the gravity of the situation and the potential long-term damage inflicted on the NLRB's ability to function effectively and impartially. The legal battle promises to be a protracted and significant test of the boundaries of executive power and the independence of regulatory agencies in the United States. The outcome will have implications far beyond the specifics of Wilcox's case, shaping the future dynamics of labor relations and setting precedents for future administrations. The case underscores the crucial need for robust safeguards to protect the integrity of government institutions from political